Great. So hello, everyone, and welcome to the first CLRNN Spotlight series of corporate governance and insolvency law. CLRNN is the Commercial Law Research Network, Nigeria, and CLRNN is a research network that was created in 2019. I'm the convener of CLRNN. CLRNN was created by an Arts and Humanities Research Council grant, AHRC network grant in 2019. And it's a network that has been established to promote research and knowledge exchange on matters relating to the development and reform of commercial law. It started by looking at commercial law in countries such as Nigeria. And that's why you have Nigeria in the name. It responds to the challenges, really, that emerging economies like Nigeria, and similar to many other African and Asian countries and Southern American countries, face in designing commercial laws that fit both their realities and the interconnected global systems through three principal means. So the first is that we have decided to create a collaborative environment in which researchers with expert knowledge of international and the local contexts, such as the Nigerian context or today the Ugandan context, can interact amongst themselves, but also interact with various stakeholders who deal with the practicalities and the consequences of any reforms to those laws. And the goal is to shape reform policies. And secondly, I'm sure that many of us would have said at some point or the other that, I can't find research on X and I'm the only one, or I'm the first person who's ever done this. And usually I respond to those kinds of requests or proposals by saying, actually, there's always someone else. You just have to dig a bit more to find that person. And so CLRNN responds to this by creating an ecosystem through which high quality research can be facilitated. Hamiisi and I have had lots of discussions already about different ideas of what we can do together, and we're looking for more people to engage on that level. And then finally, it provides an access point to informed contextual research on commercial law. Well, primarily, I would say in Nigeria, but now that we are broadening it out to commercial law in emerging economies, and right now we're starting with Africa. We are available on Twitter, we are available on LinkedIn. And if you follow our handles, you will know that for the past month now, we've been looking at IP law in Nigeria. And so we've had stakeholders write about IP law. This week, someone has written about geographical indications. Last week, they wrote about copyrights and patents and the like. But because insolvency law has a very special place, corporate governance, corporate insolvency law have very special place in my heart, I wanted to set up something specially looking at those areas of the law. So CLRNN, as I've said, creates collaborative spaces for interaction through our conferences and our roundtable events. We had our first conference in September 2019, and we had over 70 participants who came in from across 14 different countries. And so you have lots of people in far-flung places come together to discuss law and to discuss policy. We had judges, we had practitioners, we had researchers. It was quite a rich tapestry of the people involved in reform work. We also do this through roundtable events. We're holding some roundtable events next year, looking at three different areas. I think one of the areas where we've had a lot of invitation has been consumer law. And so we're looking to create that roundtable. We're hoping to have that on insolvency law as well, and IP and the other areas where CLRNN has its strengths. We also have workshops through which we facilitate the development of research. And at those workshops, we discuss research methodologies and research methods. And in 2019, we had the privilege of hosting two of the leading eminent scholars of the third world approaches to international law. In fact, they were two of the scholars that developed that particular school of thought, Professor Obiora Okafor and Professor James Gathy, and they facilitated methodology workshops for us, and we all came up to discuss, our ideas. How do we develop our concepts? What methodological approaches do we take? What research methods do we apply? For us, we believe that strengthening research on reform policy must be fed by, appropriate research methodologies. If you say that there are realities in Africa, then how have you set about identifying, highlighting, and discussing what those realities are? It is when we understand these realities that we can begin to examine what the responses to those realities have been. And so that system also creates support for early career researchers who want to understand methodology and methods much better. Many of the events that we have write-ups about them, blog pieces and the like put up on the CLRNN website. I have put the link in the chat box. So the CLRNN website offers a valuable resource for those who are interested in research output on commercial law in Nigeria by disseminating research. And also, if you've written papers and you want to give us a short blog piece explaining what your paper was about, including a link to where people can access the paper. These are the types of things that we encourage so that everyone knows where to find research, and it helps our dissemination, it helps our visibility, and it facilitates research on those areas. Membership of the CLRNN, of the network, is open to researchers, lawmakers, draftsmen, policy makers, the various stakeholders across the reform space, and together we hope that we can all contribute to the development of our policies. The CLRN Spotlight Series was introduced in 2021. I think that I was thinking about insolvency law, and I just said, look, I know Hamiisi and I know quite a number of people, but we see that there has been a lot of reforms across Africa, and we don't really sit together to discuss what's going on. And many of us have some thoughts, and we will be listening to Hamiisi today about the work that has been done, the reform work that has been done. And I know that I've had some presentations and actually had a webinar on the Nigerian version. And there were people who said, well, what about other African countries? And I said, well, I think it's about time that we also then created an avenue through which we can broaden these discussions. And we have very many interesting, I think, conversations lined up over the next few months. So this is the inaugural session, and I look forward to this developing. Well, now I'm going to introduce Hamiisi, who is going to present today's paper. So Hamiisi is a lecturer in law at the Middlesex University, London. I'll just admit, yes, this person. Hamiisi holds an LLB from the University of London in corporate law, and he holds his LLM and his PhD from Nottingham-Trent University that has done quite considerable work actually on insolvency law and insolvency law reform. Hamiisi is a member of leading research practice and academic networks such as Insol International, Cross-Border Insolvency and Commercial Law Research Network, and the British Institute of International and Comparative Law. His research interests are in the field of corporate law, comparative corporate insolvency law. He looks at UK, US, and other developing economies, and he also uses comparative legal theory. He's written several scholarly pieces in peer-reviewed journals and recently published a book titled Employee Rights in Corporate Insolvency, a UK and US Perspective through Routledge in 2020. Well, Hamiisi, I'm going to make you the host now, but I don't know how we're going to let the other people in while you are the host. We hope that we can make this work some way. So Hamiisi is just going to, no, I meant to make, sorry, I've just made Gertrude the host. I will reclaim the host and then make Hamiisi the host so that he can share his screen. Sorry, but this keeps moving about. Yes, great. So Hamiisi, over to you now.
Thank you so much, Bolanle, thank you very much. And thank you for all the colleagues who have joined. It's such an honor that I give the inaugural piece on our Spotlight series. And nice to see so many faces. Most of you we've met through research networks, events, and it's also such an important time that people coming from the continent can meet and set up something that can work towards improving or even establishing new avenues on research, especially commercial, corporate, and insolvency law, which are very challenging areas of research. I'm going to share my screen with you on the topic of the day. I'll be looking at reinvigorating corporate rescue in emerging economies, and I'm looking at Uganda as one of the emerging economies. The reason I chose this topic after having several discussions with colleagues and Bola, we wanted to explore more on corporate rescue and the rescue culture in emerging economies. And as much as I have been privileged to have studied all of my degrees in the UK, especially in the field that I really like, corporate insolvency law, having firsthand literature, firsthand professionals, like I was lucky enough that my LLM and PhD was at the same university. I had the same supervisor for my LLM dissertation and the PhD as well. So that really made me have access to good mentorship and also the literature. However, on the continent, sometimes we struggle to get readily available literature that we can draw on when conducting research. So today I'm looking at how we can reinvigorate corporate rescue in Uganda. But before I come to the topic, I want us to have a quick look at the roadmap. How has Uganda evolved over the time? Has Uganda really got a rescue culture? Or how is corporate rescue understood in Uganda, especially within the sector? Is it working? Do we have legislation that can really support financially struggling but viable businesses? Or if the law isn't working, how can we make it better? How can we reinvigorate it such that these businesses are supported to continue to exist? The topic of corporate rescue and the rescue culture, those two concepts would be understood differently. And although they have been mainly understood better in developed jurisdictions like the EU, the US, and the UK, it depends on in other jurisdictions like Africa and emerging economies, Uganda, we are struggling to understand what is corporate rescue, what is the rescue culture. If we had enact legislation, what could be the policy objectives that such legislation could pursue? And in doing so, what is the end product? And is it working? If it ain't working, how do we improve on that? So since Uganda's independence in 1961, Uganda was basing on a very old piece of legislation. Although being old doesn't mean that it's non-functional, but sometimes there is a gap between modern trends, the changes that other jurisdictions have made to their laws and procedures or processes. And if you don't really try to move in hand with the latest developments, sometimes your system or your framework may struggle to be fit for purpose. This is why we look at the law and we test its efficiency, whether it's really achieving purpose. So when Uganda got its independence in 1962, the main legislation that we had was the Bankruptcy Act, 1931, which had provisions for English insolvency law to be applicable in Uganda where necessary. But we also had what we call the Indian Companies Act, 1882. Now, this was a piece of legislation which was drafted to regulate business dealings between Indians that we are trading along the Indian coast or the Indian coast, the Indian Ocean or the Indian coast, the East African region, coastal regions, and doing trade in Uganda, trading in cotton, trading in so many other things. So this piece of legislation didn't have any provisions that provided for corporate insolvency law, provisions that would support companies or traders or businesses whenever they had financial problems, how to deal with those financial problems. So the first formal legislation we had, the Bankruptcy Act, it was a replica of the English Bankruptcy Act of 1914. And the reason being that Uganda was a protectorate of the British Empire. So Uganda was being colonized by Britain, and the law and the legal system that Uganda was using was based on British way of British legal structure or the legal system. So when we enacted our first Bankruptcy Act in 1931, it was a total replica of the English Bankruptcy Act 1914. And this Bankruptcy Act continued to be the main legislation governing bankruptcy and insolvency issues until 2011. Now you could see how long ago that legislation was in operation. And the other form of legislation was the Companies Act 1961, which was enacted to deal with all matters to do with corporate law. But this was a 1961 legislation, but it was also a replica of the English Companies Act 1948. So you could see how both legislations that deal with commercial corporate law, how old they were. So they were almost 60 years of age. So when Uganda had its problems with the financial recession, the global economic recession, policymakers and business insiders started to voice concerns on the efficiency of the law, what could be done, why there was a need to have corporate insolvency law provisions that could support financially struggling but stable, but viable businesses. So what the government did was the government of Uganda commissioned the Uganda Law Reform Commission to review the then law in the Bankruptcy Act of 1931 and the Companies Act 1961 to review its processes and whether it is still fit for purpose. However, there were certain problems because the Law Reform Commission did its work and published its report in 2004. And it was forwarded to the parliament, but nothing could be done on it until after the financial recession. And actually, it was until 2009, after the financial recession, the global economic recession, that Parliament started to move to make steps to amend and to reform the law. And this is when they tabled the Insolvency Bill 2009. Now, this bill was taking on board the recommendations that were made by the Uganda Law Reform Commission. And among the recommendations was the need to have a single statute that could regulate all matters of insolvency, processes and procedures that could support. So insolvency, both corporate and personal, that could really support these financially struggling businesses to continue to survive. And they had learned lessons from the economic recession. So they looked at the law. Some of the arguments were, if we are following the British system, or the English legal system, there has been so much legislative reforms and procedures that have been brought in to try to make or to modernize insolvency law. There was the Enterprise Act 2002, which brought certain changes that made the rescue culture more of a product of the current English rescue culture or the rescue regime. I'm not going to go deeper into the changes brought by the Enterprise Act because I'm looking at Africa, but I analyzed those changes in the paper, and I will be drawing back on them as I go along. So as a result, before I move on, I also wanted to make a note that the Uganda Law Reform Commission, in their deliberations and their reviews of the current law, they drew so much from the committee report because they considered it to be the most modern, framework within which an efficient and modern insolvency framework could be drafted. So if you look at the recommendations made, they were somehow a copy and paste, but in a more Ugandan way of reasoning. But what we could pick out from those recommendations was the need to have a single statute that could regulate all matters of insolvency, corporate and personal, and to try to overcome a high rate of liquidation of these businesses and try to support these businesses to continue to operate. As a result of the Insolvency Bill 2009, we had the Insolvency Act 2011 enacted and the Companies Act 2002 enacted. Now, so Uganda's insolvency framework is born out of these two statutes, the Insolvency Act 2011 and the Companies Act 2012. Now, in the Insolvency Act, we have provisions like the provisional administration, which is in Part 6, Sections 139 to 161. And we also have full administration, which is from Section 140 to 162. We also have voluntary arrangements. These are the company voluntary arrangements. We also have receivership and administrative receivership, which in Part 7. Then you have liquidation, both voluntary and compulsory, and cross-border insolvency proceedings in Part 11. And actually, I looked at that provision, whether it was fit for purpose in my paper when I was looking at cross-border harmonization of insolvency law, which is out. So the Companies Act 2012 has procedures like the compromises and arrangements. These are in Section 234. Then reconstructions and amalgamation, and we also have voluntary winding up. Actually, Bolanle made a note when reading my paper, why the split? Why were these two, why these two statutes had different procedures? Why compromises and arrangements in the Companies Act? And why the other procedures in the Insolvency Act? The answer is, I don't know. Maybe the draftman thought that it was important to separate the procedures that mainly looked at insolvency-related issues in one statute, and the procedures that looked at more maybe voluntary, I don't know, maybe voluntary way of sorting financial problems, corporate financial problems. So these are the two statutes that really establish Uganda's insolvency framework. However, as per the report of the Uganda Law Research Review Commission, the idea was to try to rescue companies, financially but struggling but viable companies, to continue to survive and trade out of their problems. So therefore, much emphasis was put on administration, because at the time, the Koch report also put much emphasis on administration, and the Enterprise Act was also putting much emphasis from streamlining administration proceedings. And at that time as well, they looked at administration as the bedrock that can really sustain or support or initiate Uganda's claim to a corporate rescue or to a rescue culture. Although those two concepts are different and different understood, but that's the prerequisite was to have a bedrock that could lead to Uganda having a rescue culture or a claim to having a corporate rescue framework. So administration, what they did was to break it into two pieces, so two parts. So administration in Uganda's Insolvency Act has two stages. So we have the provisional administration, and you also have the full administration. So provisional administration is the initial stage. This is where the viability test is carried out, where if a company is going through financial difficulties, the directors have the power, courtesy of the, if you look at Section 139, directors have the power to appoint an insolvency practitioner and to initiate provisional administration proceedings. Now, what the IP, the insolvency practitioner, does at this stage is to carry out a viability test to look at the sufficiency, how sufficient the assets are. Has the business got enough assets that could support it, could support the rehabilitation endeavors or not? And also such a provisional administrator has three objectives to pursue, and the main objective is to try to support the company to agree to come to an agreement with creditors. This is whereby to execute an administration deed with creditors, and if that is not applicable, possible is to support the business to wind up in a very efficient manner that could consider the interest of creditors as a whole. However, if the company and the creditors agree to the proposals put forward by the provisional administrator, then they execute what we call an administration deed. And that administration deed would provide for the next stage of rehabilitation, which is to file for formal insolvency proceedings. So provisional administration lasts for up to 30 days, and once an administration deed is executed, then formal administration proceedings commence. And like in the UK administration procedure, Uganda's administration procedure has what moratoria protection, a stay on all creditor enforcement actions to support the financially struggling companies, a breathing space to work out its rescue endeavors. And the provisional administrator that was undertaking or in charge of the provisional administration proceedings now becomes the full administrator. And he or she has three hierarchical objectives: rescue the business as a going concern, and if that is not possible, to try to give an orderly liquidation, and also like similar to what we have under Schedule B1, paragraph 3, those hierarchical objectives. So most of these provisions were really influenced by the UK Insolvency Act and the COP report. So that takes us back to our attachment to Britain, being our colonial masters as Uganda, and we carry with us the colonial overhand, like some colleagues would call it. So we still work into those shadows. Now, administration on the side, we also have another, I'm not going to go through all of the procedures. I wanted to pick out on two of the most so-called rescue-oriented procedures. So we have receivership and administrative receivership. Part of the recommendations made by the Uganda Law Reform Commission's report was to try to reform the law on receivership, because receivership was mainly considered as the most viable rescue at the time, and it didn't really consider collective creditor interests. Secured creditors would just come in, help themselves, and they didn't care whether after collectioning or satisfying their debt, the company was able to consider other creditor interests or even survive. Now, the problem that I encountered reading the law, especially the provisions here on receivership and administrative receivership, both of the procedures were put under the same section. So the only difference is when does receivership occur and when does administrative receivership occur. So what the law did was leaving it to the reader to decide if the charge, if the security being enforced is courtesy of floating charge, then administrative receivership. If non-floating, then the other receivership, which becomes a concern. So we have two types of receivership proceedings. We have administrative receivership and non-administrative receivership. Sorry, I would use those two terminologies because that is the best way I can easily put a distinction between the two. So receivership in general is where a secured creditor may appoint a receiver to enforce their security. And they may be appointed by court, they may go to court, and the appointment is made via court or per the terms of the debenture or loan agreement. These are set out in section 176. And also the government regulator official bodies like the Bank of Uganda has the power to initiate receivership, because when banks and financial institutions are going through financial difficulties, then the Central Bank of Uganda is the receiver, is the regulator of banks. So it has the power to appoint a receiver who will take over the administration of such a bank or financial institution. I've analyzed those issues in my paper looking at the role of the central bank in financial distress resolution in emerging economies when I was looking at failing banks. So another way is of appointments via the official receiver. Like currently we have the Uganda Registration Services Bureau, which is the official receiver for insolvency and receivership. So they also have the mandate to appoint a receiver to run the affairs of a financially struggling company. However, when you talk about administrative receivership, this is in sections 175 to 196. This is where a floating charge holder has the power to appoint an insolvency practitioner to enforce their security. So what the IP does here is that they, once appointed, they prepare a preliminary report on the assets charged within 40 days, and they also give notice of the receivership, the registrar general, and the public at large within 14 days. And then priority is enforcing the appointer's interest. So although there is a likelihood that after enforcing the appointer's interest, the company may still survive and continue, it is not one of the most rescue-oriented or rescue-efficient procedure, unfortunately. And they have wider powers in relation to the charged assets. Now, upon recovery of the interest, the company may not survive. If after distribution, after enforcing, after paying off the debt of the appointer and their fees for the job, if there is any, then they have to go through the insolvency distributive hierarchies. And usually there isn't enough. The reason I say that is that most of the businesses in Uganda are not really large businesses, and they are smaller businesses. If you look at the business structure of the entire private sector in Uganda, 90%, 90% are micro, small, or medium enterprises. So 90% of the businesses in Uganda are MSMEs. So they are not really large companies. And when the breakdown of those businesses, like 49%, they are in the service sector, 33% in the commercial trade, manufacturing 10%, and 8% are in the other fields. So if you look at that breakdown, it kind of ring bells why we need to have efficient rescue culture or the rescue framework that can support these, because we don't have that large companies that can support certain workout like schemes like you would look at big companies in the UK or in Europe or in EU, which can really adopt those large restructuring frameworks. So having looked at these two, and having put much emphasis on administration as the bedrock to a rescue culture, there are concerns that the procedure hasn't really served its purpose. I am not trying to look at efficiency, but I'm trying to look at the figures. Why has administration as thought that, because the policy objective of the Insolvency Act, if you look at the preamble of the statute, is to support companies, financially struggling but viable companies, to overcome their financial problems, to continue to survive. They put much emphasis on administration, but so many companies are not really using administration as a rescue tool. They look at informal ways of dealing with their financial problems, which defeats. So I looked at reasons why these companies are not really embracing administration and choose to mainly rely on receivership. If you look at the figures I obtained from the official receiver's office, in 2020, in April this year, the Ministry of Trade and Cooperatives came out in the press and said that 4,200 businesses have collapsed because of financial problems and partly amplified by the COVID-19 pandemic. Yes, before even the COVID-19, Uganda's financial businesses were really struggling to overcome their financial problems, and administration wasn't being really used as intended. When you look at the annual reports from 2017, 2018, 2019, before COVID-19, these procedures, especially administration, wasn't being used. And the Ministry of Trade came out in April and said 4,200 businesses collapsed, But then when we looked at the annual reports from the Uganda's official receiver, the Uganda Registration Services Bureau, the annual report for 2019, 2020 indicated that total filings were 91 and administration filings were only 10, and 15 were liquidations and receiverships were 66. So you could see why the trend here. If you had 91 filings and only 10 businesses underwent formal administration proceedings, and 15 took formal liquidation proceedings, and 66 receiverships, and then I couldn't find the annual report for the 2020-21 because Uganda's financial year runs to 30th June. However, I managed to contact the Director General of the Uganda Registration Services Bureau, and also got in touch with the Director of Insolvency and Receivership, who was kind enough to email me the figures so far. However, he told me that the annual report is being compiled, but he gave me the statistics for the year. And in the year 2020 to 21, there were 26 filings in total, administration only 2, and liquidations 26. So when you look at those figures, it really highlights why it is ever so important that we reinvigorate corporate rescue. We sell the idea that the law is there. These procedures are there for you. They are for you to use, and they give you protection. Most of these liquidations could arguably be overcome if rescue-oriented procedures could be attempted. I cannot say fully. However, if not tried, we cannot really come to such good analysis. So I looked at why there is a slow uptake of formal rescue procedures. And one of the most important key aspects was less awareness. Less awareness, because some of these businesses don't know that these procedures are there for them to use. There are also misconceptions in the business sector and the stigmatization that comes with the corporate insolvency. Usually you would find that a single family owns like 3 companies, and having a company filing for formal insolvency proceedings and their name is out there, maybe Madvan and Co. is going through administration, it is a stigma that it would mean that their international investors or colleagues would shun them, they won't do more business with them because they've gone through administration. Yet, it is a way that you can navigate the financial difficulties and continue to survive. So there is that stigma and costs. So many insiders think that going through insolvency proceedings is a costly exercise, and it also gives professional insolvency practitioners a chance to benefit commercially from an already financially ailing company or business. And this is the concern. So you look at that, we need to raise awareness. We need to amplify the usage of these rescue procedures. How do we do that? We have to look at, first of all, Uganda's business structures. I've already showed you that 90% are MSMEs. How do you support these? Would you have a special regime for such? Like SMEs, like a moratoria protection for SMEs that could really target those companies to overcome their financial problems? Then how do we work and amplify the activities of the official receiver? The official receiver, I looked at their website and did research. And this is one of the biggest problems we find if you do research from emerging economies. There isn't readily available data to analyze. So you have to email people. This is why it's so important, as I was telling Bolanle, that moving forward, we might have to focus on the use of empirical research in insolvency in emerging economies, because if you do empirical, you get much data that you can relate on, as opposed to going to a library to look at an already written law, or articles which are not readily available. So the official receiver in the last 3 years, I could only see one activity that was targeting insolvency or corporate insolvency or receivership. This is in April 2021. This is when they had an event called Insolvency and Intellectual Property Rights in the face of COVID. And I think this was to do with COVID, trying to tell companies what they were doing in COVID. But there is a need for more awareness of these rescue. If you are to enforce the rules, then you have to make those rules or procedures known to the people, and they should be. Also, the debt structures, and when again, the High Court Civil Division of the Republic of Uganda has the mandate to hear insolvency proceedings, but they don't have a central database where you can look at the filings to study data analysis of cases filed in insolvency liquidation. This becomes a problem. And debt structures and financing models in Uganda right now. Banks and microfinance institutions are the main lenders. So they are the ones that if these businesses could grant charges, and when they are negotiating these rights and enforcement rights, they become more secured and they have more influence over other creditors with interest in the financially struggling company. So there is a need to reconceptualize these lending debt structures and to move to see how we can support these financially struggling companies. I don't want to spend so much time because the clock is ticking too fast, but one other important survey was done by the UN Capital Development Fund in 2020. This was because there were so many concerns of businesses struggling, and they did a survey on Uganda's business structures and looking at vulnerability to corporate insolvency. So they surveyed 1,012 companies or businesses, but their findings were only 15% of those companies. So I'm not good at mathematics, but 15% of 1,012 is relatively a small percentage. Only those 15% could survive, could continue to trade for 3 months. The 85% couldn't. So there is this vulnerability, but also these businesses not really embracing corporate rescue procedures available. There is a particular interest in receivership, but receivership shouldn't be the main rescue procedure. So in conclusion, I gave at least 4 ideas on how we can reinvigorate corporate rescue in Uganda. The first one is we need to re-promote corporate rescue by using the official receiver. You are the enforcer. Try to create events, train insolvency practitioners. We have to establish institute of directors. Let them work alongside. Most of these insolvency practitioners, actually this was part of the recommendation by the Uganda Law Reform Commission. The idea was, previously, we didn't have the laws regulating insolvency practitioners. So what they did recommend was to make all insolvency practitioners be members of professional bodies. So not everyone could work as an insolvency practitioner. You have to be maybe a member of a chartered accounting body or a lawyer or an advocate. So now it's a requirement in the Insolvency Act that all insolvency practitioners are members of professional bodies. Why not work alongside these professional bodies, like the Chartered Institute of Accounting of Uganda, Insolvency Lawyers Association? Then you train them, work alongside the official receiver, raise awareness to try to amplify usage of these formal rescue procedures. There is a big question mark here when I say need for preventive restructuring frameworks. Some people would argue, some scholars and policymakers would argue that having preventive restructuring frameworks is not the way to amplify corporate rescue because they target pre-insolvency, like trying to support it. Yes, that is an argument you could put down. However, if we are to support these businesses, have a variety of avenues that these businesses could resort to in fighting financial difficulties. Now, we also have to fight, solve problems with informality. Why? We need policy insiders. We need the official receiver to conduct research and review of usage of these rescue procedures. Ask yourselves, why do businesses prefer informal resolutions as opposed to formal resolutions? Look at the figures, do the math, put in reviews that could take forward and amplify corporate rescue for the better of the Uganda's economy. I think there was some movement prior to the outbreak of the COVID-19 pandemic. This is when there was the official receiver made arrangements to review the Insolvency Act and to simplify liquidation procedure, and also to make some amendments to the Companies Act 2012 to simplify registration and administration of companies. In both attempts, the regulatory impact assessments were made, and they were forwarded to the first Parliamentary Council for further processing, but nothing has been done. This was done in 2018. As of date, no movement whatsoever. So thank you very much for your time. And those are the findings that I could share with you in relation to Uganda's corporate rescue laws and procedures, and in Uganda's quest for a rescue culture.
Thanks very much. Can you hear me now?
Yeah.
Yes, thanks very much, Hamiisi. Well, I have reclaimed my host position now. And I'll just say thank you very much for, starting us off so splendidly. I know I gave you very short notice to come up with a paper, and you have done very well. I didn't know anything about Ugandan insolvency law before reading the paper. It's interesting. One of the things that I tell people about the last 1 year, when there has been a lot of discussions about race across different spheres, is that people do not realize how very little in Africa we know about one another in Africa. And today I was in a different conference where they were discussing international economic law, and it was mentioned there by someone that their nephew was being taught history, but they were being taught about the founding fathers, and the founding fathers like George Washington and the like, and you're like, no, whose founding fathers are those? That's the US history. How about the history of Nigeria, where you actually live? And they didn't know figures like Obafemi Awolowo or Nnamdi Azikiwe, and we don't know very much about one another. We don't know very much about our own countries in Africa, and we don't know very much about the other countries that are in Africa and the shape of their law. So for me, I found that it was very enlightening. The presentation was, and I had the pleasure or the privilege of reading the paper as well, and I found that very enlightening as well. So I'm going to act as discussant today, and I will start by giving my thoughts about the paper, and when I'm done, I think I will complete with a couple of questions for Hamiisi to answer, and I welcome everyone else coming up with questions, and then maybe the last 15 minutes we'll use that to discuss how we might take this forward, if that's okay by everyone. So I would say that it was great. Well, it was interesting to see that the Cork report appears to have impacted reforms in Uganda, as it appears to have done in Nigeria also. And clearly the colonial overhang, which Hamiisi and I were discussing before we started today's presentation, has played a very interesting role in the reform of insolvency law across Africa. And I would say, in fact, like I said, one of the things that we want to do is to have a discussion about research that is available. So I'm just going to put Damilola's paper, the title of Damilola's paper by, I think I'll put her name, Damilola Adebola. She's on the call. She has come in from her maternity leave. I'm sure she didn't realize I was going to mention her. She wrote this award-winning paper for the International Insolvency Review, and she was looking at the political economy, the background to the insolvency law reform across Africa, the journey to that. And one of the things that she discussed was the political economy of that reform journey. And I know that Tifidigbe is on the call as well, and he's also doing some work looking at the relationship between Insol and, I think, the making of cross-border insolvency law. And I think that these types of research help us to better understand our reform journey. And what I'm hoping that we will do is to take these conversations even further, to look at Africa's approach, for example, to legal transplants. It's interesting to see that although Uganda took up, administration, for example, they have
tweaked it a bit. If you look at the insolvency law reforms in Nigeria, we also picked, I think Nigeria, you said you've picked Uganda picked pre-2003 insolvency law in the UK, or 2002, which came into effect in 2003. Nigeria picked a mash of both. So you see both pre and post 2002 insolvency laws from the UK in the Nigerian insolvency law reforms. And I think that part of this perhaps was the manner in which the insolvency law reform was done. So it took a period of time, and over that period, different bits were just put in. But it was interesting also to see some of the adaptations that were made. And so looking at Nigeria, crucially through the methodological lens of comparative law and legal transplants, would be an interesting thing. And that brings me to some of the key questions or ideas that I want to share. The first is looking, say, at the structural issues, and then looking at conceptual issues, and then finally ending with some of the substantial issues. So structurally, I know that I had given some feedback and initially, and that you had helped us to better understand some of the challenges I think that Ugandan companies face. But it would be great really to understand what the level or the nature of the law was initially, because for me, you were talking about administrative receivership and non-administrative receivership, and for me, who is a Nigerian and for whom the 1948 Companies Act was also a pivotal Companies Act of England and Wales was also pivotal for Nigeria. It's influenced our Companies Act for quite a while now. The 1968 Companies Decree, the 1990 Companies and Allied Matters Act, and that was the basis of it, the English Companies Act 1948. We understood what the receiver simpliciter was, and the differences between the receiver simpliciter and the receiver and manager, who was then what was transformed in 1986 in England to administrative receiver. And so it again, makes me wonder, what did Uganda actually have? What was really the nature of the law? Was it that you didn't even have receivership at all? Was it that there was simply only the liquidation option? So again, for me, I want more. I want to better understand the problems. I want to better understand the law. I want to have a definitive explanation or exposition of that old law, and then I can start to see the steps that have been taken. Then that would help me better understand the challenges that the practitioners had, and why perhaps Uganda has had a propagation of informal systems as opposed to the use of more formal systems. Because again, that leads me to questions like England in the 1970s, when the London approach was created, because the formal insolvency procedure was not effective enough or efficient enough to resolve the types of challenges that they had. So for me, those are some of the structural challenges that I will pose to you. And then I move next to the issue of some of the conceptual challenges and the conceptual issues. And part of this is also methodological. So at the heart of the paper is this notion of a rescue culture. And like I said to you, you didn't explain the rescue culture. Sometimes you talked about corporate rescue, sometimes you talked about a rescue culture. I think that in this presentation, you seem to have now included administrative receivership as part of the rescue culture, because I had said, if you read my PhD thesis, for example, in chapter 3, what I discussed there was the notion of corporate rescue and what we're doing with this idea of corporate rescue. And I looked through the debates in the US and the UK, which were quite well developed, and some of the ideas that were being bandied around was whether corporate rescue meant the rescue of the company. That's Alice Belcher and co, that notion that she put in her book, and that's company rescue, and that's what the US practices as company rescue. Or whether the notion of business rescue, that's ejecting the functional bits and the profitable bits of the business out of an insolvent company, hiving that down and putting in a new company, which we know as business rescue, which is what administrative receivership is supposed to do, whether that qualifies as corporate rescue as well. And what my conclusion was there was that both company rescue and business rescue for me would combine in this notion of corporate rescue, because corporate rescue is vague. And for that, I had to look at the meaning of vague and the meaning of ambiguous. And the argument was that a notion or something is vague when the ends of it cannot be properly delineated. Therefore, you cannot say that you exclude something or that these are the only things that will be included in it. And so, those are the conceptual challenges that I face. And I then start to ask myself, well, how does one set about answering these questions? Those are the issues of, normative theories, normative ideas, conceptual theories, conceptual ideas. Another key aspect of your paper is this, well, we changed the law, but nothing changed in the behavior for the next 10 years. And again, that actually sits within a body of work, which some of whom I flagged out to you. I know I flagged out mainly the law and economics people, so Posner and co. And one of the things that they discuss is the relationship between legal rules and social norms. Does a change in legal rules necessarily lead to a change in social norms? So what Uganda has had is that there has been a change in the legal rules. What you say is that there hasn't been a change in the social norms. So what is the relationship between legal rules and social norms? And I think that if you explored that you would find that. I think that John Armour also wrote something about, propagating norms in insolvency law, and how the norms that made up the London approach then helped or contributed to the creation of this rescue culture from 1986 down in the UK. So I think that it would be great to also strengthen some of the normative arguments that are made by looking at some of these theories. We also discussed, things like the colonial overhang and the legal transparency and the like, and all those can be done. In terms of the substantial or substantive issues, again, I have two quick points. One is that I didn't quite understand the difference between this administrative deed and rescuing the company as a going concern. And for me, it would be great if perhaps you did it in this comparative way. I don't know if that's a different paper to say, well, administration in Uganda versus administration in the UK, because I needed a better understanding of what there were three objectives in Uganda, as there are three objectives in the UK, but I don't understand the Ugandan process. And finally, it's the point of, you said, well, administrative receivership does not bring the rescue culture into effect. And those were some of the key points that you argued in the paper, and you just snuck it in at the end during your presentation. And again, that just takes me back to the conceptual problem. Well, if you explain what your concept of rescue is, then I would better understand whether administration or administrative receivership is the one that works. And if we're just to pull in an insight from the UK, administration doesn't rescue companies either, is what I think empirically has been found in the UK or in England and Wales nonetheless. But I would just stop by saying, well, I found the paper extremely interesting. It was great to see what has been done in Uganda. And those are just some of the structural, conceptual, and substantive points that I would like to make in response. So I don't know if you want to respond to that quickly, and then we can open that up, or if you just want us to open it up immediately.
I can respond quickly to some of the issues you've raised. And the first one I want to start with is the difference between administration deed and administration. So administration deed is like a document that the provisional administrator oversees. So you have a provisional administrator in a provisional administration. When I look at provisional administration, it's like, and I compare it with the UK administration, it's like having, giving the company a chance to attempt rescue before going to court or filing formal insolvency proceedings. So you have a company who realizes that, look, the directors think we are in need of professional support. We are financially struggling, but there is a likelihood that we can overcome this problem. So they appoint, they approach an insolvency practitioner. In this case, he is now the provisional administrator. So what he does is he carries out a viability test. Like a professional to come in, you look at the assets, the balance sheet, how many assets you have, much is in assets, the total debt and all that. And then if he thinks that there is a likelihood that you can overcome that, then he would approach creditors and table his proposals that this is what I'm proposing, and this is how we can overcome these problems. And once the creditors agree to the proposals put forward by the provisional administrator, then they execute a deed, which is a document that binds creditors and the company and takes them to the next stage of formal insolvency proceedings. It's like looking, I don't want to take you into pure corporate law, but looking at a derivative claim. When you look at the statutory derivative claim under section 262, you're having the first stage of looking at whether there is a case anyway for a claim, and the other two is proceeding with the claim. So the same here, that the draftsman thought to do, like to give companies a first say. Well, otherwise, what's the point of going through formal administration when you couldn't really realize what you intended? So that is, I think that answers your question as well. And what happened in the 60s and the 70s in Uganda was like, yes, we had the law, and at the time it was functioning. It was the main law that guided people, actors in the field. But as years go by, the trend, international trade, international trends, international commerce, these things change. And sometimes, for example, in the 1950s and 60s, or even 70s, we didn't have too much cross-border business transactions that could warrant an area of law that could regulate that. Now we have cross-border business transactions. You could see that a company is in Uganda, is buying from China. They have also subsidiaries in the neighboring countries, like in Kenya, in Tanzania. For example, supermarkets, you have Uchumi, Nakumati, you have companies, and so this is a problem. So there is cross-border activities. Now, if you have a certain legislation that doesn't have provisions for cross-border dealings, then it won't serve the interests of that area. So this is why it is important that there is a review of the law to move with developments at international stage or regional stage. Uganda, we have the East African Community, we have the Common Currency Protocol, we have all of those protocols in place. So it is important that if, for example, I don't want to talk about COVID because that's a topic for another day, but for example, if we have COVID-induced changes, legislative changes, if Uganda enacts some certain changes, then Tanzania, Kenya, Rwanda ought to implement such changes. Why? It becomes a problem in enforcing certain legislative regimes when another member state isn't really having such reciprocating legislation to deal with issues. So this is why, yes, the law was good, but in 2005, 2006, we don't have cross-border insolvency provisions in our Bankruptcy Act 1931. What happens? Then you have companies coming in from Kenya, establishing companies, then they have financial problems in Kenya, or they close the one in Uganda. They run away and then you have creditors who are left empty-handed because there isn't a legal regime or legal framework that can protect their interests. So this is why it was in need of changes.
Okay, thank you. Thank you very much. That was, as always, interesting. I wonder if there are other people who want to chip in, questions, comments. This is the, I think, interactive end of things now.
Hi.
Okay. Yes, Obiora, we'll start. I'll start with you.
Yes, so thank you very much, Hamiisi, for that wonderful presentation. My name is Obiora. I'll just have to introduce myself. I'm a lecturer in law at Coventry University. So the question is, although I'm not very familiar with this area of law, but I think this actually ties in with what Bolanle, one of our observations I think when we were actually discussing, the informal arrangements and how it takes up, 90% of what the parties adopt in Uganda, I think the question I have is, informal arrangements, is it also one type of corporate rescue? And I think I asked that question in terms of the definition of corporate rescue and whether, administrative receivership is actually one type of corporate rescue. The informal arrangement, which you refer to, is also another type of corporate rescue. I don't know if that actually makes sense.
So, okay, we'll take that, and then I'll just take two questions in a trot. Was it Damilola who, or I don't know, there was a female voice, I wasn't sure who that was because I didn't
yes, it was me.
I thought I recognized it. Yes.
Oh, should I go on now?
Yes, so we'll take your question as well.
Okay, I'll be quick before I get interrupted by this infant. Apologies in advance if that happens. I'm just really curious about how the few administration cases have gone. I know you mentioned Hamiisi, and thank you for that insightful presentation, by the way. I know you mentioned that there have been very few, and I'm just really interested. I'll be interested to know how they've gone, what the outcome was, how the process, if you know how the process went, and if there's like any real prospect of, if eventually the word gets out and people start using it, if you think that it's going to achieve purpose or be fit for purpose. Just any comment or any insight you have into how the few administrations that have been done, how they went. Thank you.
Hamiisi, over to you.
Okay, thank you very much. I would answer Obiora first. Is informal rescue not good for businesses because the SMEs? I'm not arguing 100% that informal rescue isn't good. I mean, if it can work, it's good for these small businesses as well. But the problem is that how do we test the efficiency of those informal rescues? How do we, because we are struggling for data. We can't clearly have data that these companies have really managed to overcome their financial problem informally if we don't have a central database dealing with those. Yet the idea is to establish a rescue culture based on the rescue framework, corporate rescue framework. So the idea is be formal, follow these channels, and then we can see how the law is fit for purpose and how we can move forward. The problem now is that the official receiver is also struggling for these for the data, and if then you have a minister for trade and cooperatives coming up and say such and such number of 4,200 companies or businesses have gone down under, and then when you go at the official figures, you only get 2 or 3 cases that have gone through the formal road, and these. Usually, according to research, which is mainly newspapers, because there isn't so much, these companies that go informally, other creditors are not protected. This is the problem. The law, if we go formal, we have a collective creditor interest at hand of rescue. But then you have, if you do informal rescue, for example, the law would give creditors a chance, if they're doing an informal workout, to appoint a committee of creditors and to represent creditors on that committee. But research has it that the most exposed creditor, the most powerful ones, they influence the selection procedure. So they have more bargaining powers and they satisfy their debts at the expense of other small creditors, which defeats the overall purpose of rescue. If we are to support these companies and creditor interests as well. It is an argument that you could, that you could fight, but informal workouts are good for big companies, really, for large companies. But if you have an economy sector which 90% are MSMEs, that becomes a problem. This is why we are in favor of formal corporate rescue proceedings, where we can have data readily available. We can analyze the data and we can make recommendation whether there is a need for reform or we are meeting the objectives. Because the rationale for the law is we have objectives. And the objective of the Insolvency Act is to promote the rescue culture.
I'm going to speed you up there because I want you to answer David's question.
The other one is Damilola asking about how these a few administration cases went. The cases are there. Unfortunately, I couldn't really analyze these cases in the paper because it would go over broadly, but I'm writing another follow-up paper on that. We have a few cases really that have gone through administration. The problem is that some of those cases get protracted and go on because they've been extended. We have a key case, UTL, Uganda Telecom Limited. Since 2018, there are issues going on. You see that Uganda Telecom Limited, there are so many other cases that have been filed. The administrator is counter suing the other one is suing. So some of them are easily concluded and others are protracted. And they are long, and the company stays in administration for longer than anticipated, which frustrates creditor interest as well. I'm happy to email you a few cases that I have on my work in progress, and then we'll take it from there.
Okay.
Oh, great, thank you.
Well, thanks. I hope that answers, at least starts to answer the questions for Obiora and for Damilola. Well, I wonder if we had, I think I'll sneak in one more or two more questions. Do we have any more questions or comments? Okay, so I think that
I have a question for Dr. First of all, thank you for the very good presentation. My name is Hansen. You indicated about the cross-border insolvency proceedings that matters when it comes to insolvency proceeding when you have multiple companies in different countries. By the way, I just want to find out, in the Ugandan case, has there been any attempt to have a uniform, approach to have that incorporated into the law? And if so, which institution is championing this particular, aspect of it for cross-border insolvency proceedings to be added into the law? As I speak to you now, Ghana passed its law, the Corporate Restructuring and Insolvency Act, which is forward-looking. It has certain provisions that Doctor mentioned. More critically, it's insolvency practitioners having cross-border insolvency proceedings and administration predominantly. So I just want to know, Doctor, has there been an attempt to have that incorporated into the law, since you rightly mentioned that it is very useful to have that, especially to protect creditors' rights in such circumstances? Thank you.
Well, was there? I can see that someone else is has unmuted themselves. Did they want to ask another question quickly? No. Okay. Hamiisi, we'll take that question and then just talk more broadly about the network after that.
Okay, thank you very much, Hansen. Yes, Uganda's Insolvency Act has provisions on cross-border insolvency law, and what they did was copy and paste the provisions in the model and Citro model law, the 1997 model law. The provisions on cross-border insolvency law is what they copied and pasted into Uganda's insolvency law. I think I was trying to pull it out. It's under, I think, part 10 of the Insolvency Act. I analyzed those. I'm happy to share with you my paper I published on cross-border harmonization of cross-border insolvency law in the ESE, in the East African region. It is International Company and Commercial Law Review. It came out in 2019. I'm happy because I analyzed cross-border insolvency law across the ESE, looked at Kenya's cross-border insolvency framework, Uganda and Tanzania, and Rwanda and Burundi have none, but they have yet to transpose those provisions. So I analyzed those. I'm happy to share that paper, I think, if it can help.
I'll be most grateful, most grateful. Thank you.
Right. Could you email me your email address, then I will forward it to you, please.
I'll do so. Thank you. Thank you.
All right.
All right.
Great. And I think that I'm going to stop the recording now. That brings us to the end of Hamiisi's presentation. Hamiisi, thank you so much for setting the bar so high. Now, those of us that are coming after you have to really think. I will just quickly put a plug to say that next in August, Kenneth Garty is going to unpack the Ghanaian insolvency law for us, and I'm really looking forward to that as well. So I'm going to stop the recording now.